So good morning, everyone, and welcome to a Guide to Effective Arbitration Advocacy. This is a webinar co-sponsored by the University of Florida Levin College of Law, Institute for Dispute Resolution, and Upchurch Watson White & Max Mediation Group. My name is Richard Lord, and joining me this morning are my colleagues Michelle Jernigan and George Sprinkel. We are all three active arbitrators here at Upchurch Watson White & Max, and we hope that you find this webinar to be both helpful and interesting in your arbitration practice. Continuing education credit information, including the Florida Bar course number, will be provided at the end. In addition, this webinar is being recorded and will become part of the webinar archive on our firm website. Before we talk about arbitration practicalities and practice, we want to share a little about the genesis and history of arbitration. And that's something that Michelle has done some research on.
Well, good afternoon or good morning, everyone. It's a pleasure to be here with you all, and I hope we've got some insight and information that's going to be useful to you. I don't know if you recall the expression split the baby, but that arises out of one of the first references we see to arbitration, which takes place in the Bible. And basically what happens is King Solomon is presented with two women who are fighting over one baby. They're both claiming that the baby is their baby. And so King Solomon decides to resolve the dispute by saying that what he's going to do is cut the baby in half. Well, he was a very wise man, and he fully recognized that once he offered that up as a solution, that the real mother would agree to give up her baby just to save the baby's life, which is in fact what happened. So that's really one of the first references we see, and that's where the phrase split the baby comes from. Then in 337 BC, we see Philip II, the father of Alexander the Great, used arbitration as a means to settle territorial disputes. We then see arbitration coming into vogue in England in the context of commercial dispute resolution in the year 1224. And then, of course, the Romans used arbitration as a means to settle commercial disputes in the Middle Ages. And then I'm sure most of you are familiar with our own Native American tribes here used arbitration within the tribes to settle disputes and with other tribes to settle disputes between them.
Michelle, can you tell us a little further about the evolution of arbitration in the U.S.?
Sure. We see arbitration used in the time of the U.S. colonies, and in fact, George Washington actually served as an arbiter of private disputes. And then in 1925, the Federal Arbitration Act was adopted by Congress. All 50 states have enacted an arbitration act or code, and most of them are modeled off the FAA, which is how we refer to it. And then we have in 1935 the National Labor Relations Act being passed, and then in 1945 the War Labor Board was created to resolve by arbitration labor and management disputes. And the primary reason for that was they wanted to prevent work stoppages that were related to wartime production. Then, of course, we have our own Florida Arbitration Code that was enacted in 1957.
As I mentioned, George, Michelle, and I are three of our active arbitrators here at Upchurch Watson White & Max, and our observations stem from our experience arbitrating a variety of cases. George, you want to talk about that?
Sure, Richard. Pleasure to be here. The types of arbitration cases that we typically see are consumer cases, commercial cases, construction cases, med-mal cases, nursing home cases, security cases, med-arb in class actions, that's mediation, arbitration, and class actions, by agreement or court order, and binding and non-binding arbitration.
Michelle, do you want to address what we mean by med-arb and class actions a little more?
Sure. I actually had the opportunity, say 10, 15 years back, to be involved as a mediator and arbitrator in a class action settlement. It was an insurance case, and it involved basically going back and reworking insurance policies pursuant to certain guidelines. And the way we accomplished this was pretty interesting. The program was set up so that we were specifically trained as mediators and arbitrators. And what we would do is we would have a mediation session by phone. It would usually last about an hour. And we would have several different options that were available to us as mediators, and there were options that the parties had in terms of what the resolution could be. And so we would seek to mediate first and see if any of those options were appealing to the parties, and then if the case didn't resolve in mediation, then it would be set about a month or two down the road for a telephonic arbitration. And at that time, we as the arbitrators were charged with the responsibility of hearing the evidence and actually plugging the evidence into specific formulas to determine exactly how the life insurance policies would be revised or changed, and that would in effect be the ultimate outcome of the case. So one of the things that I learned from participating in that process is a hybrid process can be a very useful type of process to utilize if you're dealing with a class action case where the ultimate result isn't going to be simply about a monetary award.
And George, you wanted to say a little bit more about construction, I believe.
Yes, I think that's one of the types of arbitration cases that we see quite frequently. It's very document intensive. There are usually a number of expert witnesses, and it can be a lot more complicated than your typical arbitration or even a trial, whether it be a non-jury trial or a jury trial. So construction does lend itself particularly to arbitration.
Now, there are other types of cases that are subject to arbitration. For instance, certainly there's a significant amount of arbitration being conducted in the international arena, such as under the United Nations Commission on International Trade Law, and those matters arbitrated pursuant to the International Center for Dispute Resolution. And there are other areas such as grievance arbitration pursuant to labor contracts, domain name arbitration, and maritime. And what we're sharing in the coming slides may not be applicable to, or suitable to every case. Michelle, tell us a little bit about the big advantages arbitration was contemplated to have and should have over traditional litigation.
Sure. Well, one of the primary ones, Richard, are cost savings. Arbitrations historically have cost less than litigation. This is because arbitration traditionally operated with little or no discovery and almost no motion practice as well. But what we're seeing in the recent years past, I would say the last 10 years, we're seeing arbitration conducted a lot more like litigation. And as it is conducted more like litigation with more discovery, increased motion practice, the cost goes up dramatically. In fact, in my research, I did discover that document discovery alone, and this is just in the context of litigation, but document discovery alone accounts for more than 50% of litigation costs in the average case. So if that's true in the litigation process, I think you can see that it would be true in the arbitration process as well. So if we add that discovery component, and if we conduct discovery in arbitration like we do in litigation, then I think that you can essentially expect that you're going to double that cost. And then the same would be with the pre-hearing motion practice as well. The more motions that are filed and have to be heard by the arbitrator prior to the hearing, it continues to drive up those costs.
Another advantage in arbitration is that it does proceed more quickly than litigation. One arbitrator cases, single arbitrators, proceed more quickly than arbitration panel cases. because there's less coordination of schedules involved, and most arbitrations can be started and finished within a year. One of the best benefits of arbitration is that it has very limited rights of appeal. With arbitration becoming more like litigation, the benefit of finality may be eroding. By way of example, reasoned awards have greater potential for diminishing finality. We'll discuss reasoned awards later.
And the arbitration awards are typically not reviewed by the courts, and therefore they provide limited to no judicial precedent, though they may be potentially related to other arbitration proceedings. And one of the points that should be raised here also is that arbitrators do not have to be lawyers. We are all lawyers, but sometimes you might have a highly technical matter that would call for a different type of expert decision maker. And the parties in arbitration can select individuals who are subject matter experts. Michelle, is there something you'd like to add?
Sure. I just wanted to mention two things that I think are probably the greatest advantages of arbitration over litigation. And the first one is privacy. Obviously, if you have a case that you do not really want in the public domain, then you might want to consider arbitration. And then secondly, what I like about arbitration is it gives you the opportunity to design a process that basically fits the fuss. We're going to talk a little bit more about that later, but you get the opportunity to examine how you feel you need to present your case, and then you can, in essence, as long as you get the other opposing counsel to stipulate, you can kind of design an arbitration process that really best meets the needs of your particular dispute and your particular clients.
Now, as for the advantage of finality, there are grounds in the Florida Arbitration Code and the FAA that speak to the vacation or vacating of arbitration awards. While some of our listeners may be from out of state, we're going to be looking in this webinar at the Florida Arbitration Code. You all out-of-state practitioners should certainly review the applicable code to your jurisdiction or dispute. There are 5 grounds under the Florida Arbitration Code for vacating an arbitration award. You can see that generally they relate to misconduct by the arbitrator or arbitrators. When arbitrators exceed their powers, that is perhaps sometimes seen when there's an awarding of attorney's fees, when there's no authority or agreement that makes that something that is to be decided by the arbitrator or arbitrators. Michelle, can you tell us a little more about vacating awards under the Federal Arbitration Act?
Yes, basically the grounds for vacating under the Federal Arbitration Act are really identical to those under the FAC, except that number 5 is excluded. But of course, even though it's not a specific statutory grounds, you cannot go forward or compel arbitration if there's no agreement or provision for it. So even though in the FAA they don't list number 5 as one of their grounds to vacate, it certainly is a common law ground that can be utilized. And then I wanted to talk just a little bit about some federal court history, because I thought it was kind of interesting as I was doing my research. I noticed that for years a number of the federal courts allowed a more expansive interpretation of when an arbitration award could be vacated. In addition to the 4 statutory grounds that are set forth in the FAA, there were a number of federal courts that were applying a doctrine called the Doctrine of Manifest Disregard of the Law. And basically that doctrine indicated that an arbitration award could be vacated on the statutory grounds, but it could also be vacated if, number 1, it was arbitrary and capricious, or number 2, its enforcement would be contrary to public policy. Well, you can see with that type of language that it really would open the door to contest arbitration awards. So ultimately, in doing the research and shepherdizing the cases, I discovered that there was a U.S. Supreme Court case, Hall Street Association LLC versus Mattel, Inc., and that's cited at 552 U.S. 576, It's a 2008 case. And in that case, the court held, the U.S. Supreme Court case, held that the statutory grounds for vacating an arbitration award cannot be modified by contract. Then what we see after that case in 2008 is federal courts, and in particular the 11th Circuit, because that's where most of us practice, have extended this holding to conclude that there really are no longer any judicially created bases for vacating an arbitration award. So while we had judicial expansion for a while, now we see the U.S. Supreme Court and the federal courts tightening up. And I just might also add that the state courts, at least in Florida, have not had this judicial expansion. The state courts have typically had the pretty narrow grounds for vacating awards, and those are the ones that are set forth in 1 through 5 on the slide.
Now, there have been various surveys and studies lately, including those of the American Arbitration Association, that point to delays and higher costs driving down satisfaction of those who arbitrate their cases. There's a really good discussion of that in the August to October 2012 Dispute Resolution Journal put out by AAA. Arbitrators who failed to manage the process, unprepared advocates, and those who acted as though it were litigation are often the causes of dissatisfaction, and it can even stem from poorly drafted clauses in the first place. It may be a good idea for there to be a budget to direct the planning and activities and to catalyze cost containment. These are all things that we're trying to address here. Michelle, did you want to say a few more words about this?
Yes, I had the opportunity to come across some of the writings of author and law professor Thomas Stepanowicz, and I like what he said because he really did emphasize in this quote I'm going to read to you how arbitration can be used as an effective tool and how not to diminish the effectiveness of it. He says, do not allow arbitration to become more formal, more costly, more time-consuming, and subject to hardball advocacy like litigation.
Now, speaking of efficiencies and costs and budgets, the number of arbitrators may be set by your arbitration clause or stipulation you've reached or perhaps court order. But when it hasn't yet been set, you have a decision to make. George, what are some of the things that should be thought about when people are making that decision?
Well, panels usually involve 3 arbitrators with one serving as the chair. And the chair generally handles the procedural issues and manages objections at the hearing. The real advantage of a panel is that you have 3 decision makers. The real disadvantage of the panel is that you have 3 decision makers. If your case is direct and you want to proceed as economically as possible and as quickly as possible, then a single arbitrator would be an advantage to you in arbitrating your case. The 3 arbitrator panels require much more time involved in scheduling to have all present and have all the parties present and the witnesses available either through appearance or through appearance in person or by telephone or video. And there is an advantage with going with one arbitrator on shortening the time factor and clearly shortening the costs involved as well.
Michelle, do you want to speak a little bit more about perhaps the benefits of panel decisions as opposed to a sole arbitrator decision?
Yes, sure. I've had the opportunity to serve on a number of panels, and let me first say that most panel decisions are by majority, but that's something that you need to look into before you move forward in submitting your case to a decision by a panel. You need to determine whether it's going to be unanimous or whether it's going to be by majority, and basically 68205 Florida statutes provides that it will be by majority unless otherwise provided in the arbitration provision or arbitration agreement. So in essence, the default is always going to be decision by a majority, but if for some reason you wanted your panel to have a unanimous decision, that's something that should be addressed in advance. But one of the things that I have seen as the benefit of a panel is that each one of the panel members views the evidence through their own lens, and they're going to analyze the issues in a slightly different way. And I think that having the opportunity to serve on a panel and having the opportunity to deliberate and share our views of the evidence and analyze the issues together sometimes can really be a benefit.
Now, George has already talked a little bit about some of the benefits of a sole arbitrator. Certainly, it is more time efficient and cost effective. Some agreements are going to provide for this from the outset, and you may have stipulations that you can reach, and I've seen court orders directing parties to arbitrate with a sole arbitrator. Now, we've talked a little bit about how many arbitrators you might have. George, what do you look for when selecting the arbitrator?
Richard, I think one of the most important attributes of an arbitrator is obviously neutrality. The critical support as far as the integrity of the process is this quality of neutrality. And the best way to know if the arbitrator is neutral and fair is to ask for the opinions of others who have worked with that arbitrator.
And in addition to neutrality, what else should parties look for? Michelle?
The ability of an arbitrator to manage the process is also pretty critical. You've got to have someone who can keep the parties on track, require them to proceed in an orderly and efficient way, and obviously the preliminary hearing and scheduling order is really what kind of institutes the order of the process itself. That's typically prepared by the attorneys or by the arbitrator, or prepared by the attorneys and reviewed and refined by the arbitrator. But that document's going to detail the process. It's going to be utilized by the parties to keep things on track. It's kind of akin to a case management order that you see in a litigation process. But it really is the arbitrator's responsibility to ensure that the parties keep up with and comply with the order.
And to that end, the arbitrator should take the initiative to hold case management conferences to keep the process streamlined and on track. I think it helps when we're talking about the preliminary or initial scheduling conference to potentially have not only counsel attend, but also representatives of the parties attend as well, so that they too can understand the importance of a lean, efficient process. Having your client on the phone for that initial scheduling conference will help them understand why your arbitrator or arbitrators may be limiting discovery, limiting motion practice, and frowning on rescheduling, or anything else that could increase their costs and chances of reaching a point of delay or rescheduling.
Richard and Michelle, the last category there on the slide is titled decisiveness. And that may seem apparent to everyone, but it's very important that in retaining a neutral to decide a dispute, it must be someone that you are confident is capable of making difficult decisions and making them in a prompt and efficient manner. Decisiveness can be applied to pre-trial motion hearings, setting them promptly and ruling on them at the hearing. And I've always felt when not giving a reasoned award or a reasoned opinion that I should make my decision as the arbitrator in the presence not only of the attorneys but the parties to that arbitration, and to explain to them why I feel it's I've made the decision I've made, to give them an opportunity to understand why I'm ruling the way I am. I think that's very important for the parties as well as for the attorneys, and of course making that decision in the presence of the parties at the close of the arbitration, shortens the cost factor, the time factor, and gives you a prompt decision.
Now we've talked about traits of the arbitrator. Let's now talk about traits of the effective arbitration advocate. Michelle?
Well, I feel like a mom when I get on this topic, but I can't really overemphasize the importance of preparation. You know, I have seen over the last 25 years as a mediator and arbitrator that there is a direct correlation between preparation and results. The more prepared the lawyers are, the better they present their case, the greater the potential of their outcome. And so what I would stress here is know the facts of your case, understand the legal issues, create a theory of your case. Even an arbitrator, although they're not a jury, they do kind of want to know what is your story. You know, each side has a story, so your case should fit into some type of theory or theme. And know your clients, know their background, fully assess your adversary. And one of the things I like to emphasize is that we in law school all learned how to take both sides of a particular dispute. And I think that one of the things that will really prepare you is before you get to final hearing, and of course you should probably do this early on in the arbitration process, really examine the case from the other side's perspective. If you were on the other side, what are the arguments you would make? And so that puts you as an advocate in a position of being able to successfully respond to those arguments prior to the time that you get to the hearing phase. I also like it when the advocates tell the arbitrator or tell me what you're going to prove in the beginning and how that proof establishes each element of the causes of action that you've pled. And then I like it to hear in the closing argument how you have presented evidence that does tie into the very specific elements of the causes of action. And then when it comes to damages, you know, we're more analytical than a typical jury. So when you're presenting evidence to a jury, you may not be specific with regard to pain and suffering damages and things like that, but arbitrators tend to be a little bit more analytical, and I think it would be very valuable for you to tell us specifically why you think your client is entitled to the damages that you're seeking.
And related to the topic of preparation, organization, calls for thought to how you're going to present the evidence, how you're going to present your case and your defenses. It should be in a concise, streamlined manner. Advocates should also, I think we could put here on the page of preparation and organization, creativity and I think being creative and being cooperative and open to doing things in a different way than you would perhaps in the courtroom is an important characteristic. Seeking cooperation on the process and the procedure while potentially disagreeing on, the substance or merits of the claim, is, I think, an important part of effective arbitration advocacy. So, George, what are some additional traits that you'd like to add?
Richard, I think one of the most important is being disciplined in remaining focused and efficient in presenting your case during arbitration. And sometimes it's evident that attorneys during an arbitration are trying to present the same theory or the same facts from 5 different directions. You see that oftentimes in jury trials where we have jurors who are average citizens trying to accept sophisticated theories, and you don't have that in an arbitration. You have an experienced attorney or an experienced arbitrator in that field, and in essence you don't need to try the case 5 different ways. The arbitrator will appreciate your being concise in making your points. When you do your direct examination, get to the point and And when you're doing cross-examination, make your point and then move on. Concise and disciplined is very key to effective arbitration.
I'm kind of expanding a little more on what I meant before about working cooperatively. I think coming up with and sticking to a schedule, as we've already referenced, limiting discovery to what will actually help the arbitrators will be important. Trying to avoid fishing expeditions and blistering discovery that you may have in litigation is important. And I think that limiting motion practice to those motions that would be material and likely to succeed is very important as well. Motions that impact the potential timeline and which won't impact the decision on the merits should be discouraged. And I think it's a good idea to have a telephone conference, perhaps with all the attorneys and the arbitrator or arbitrators. And the purpose of that would be to ferret out all this regarding motion practice before it's actually filed. That way you're only filing motions when necessary. Another area that I think would be ripe for cooperation with the other side is how you use experts and how you present expert testimony. To that end, you may consider a joint meeting of experts. Perhaps that joint meeting can be used to generate a joint expert report on areas where the experts are in agreement. That can certainly help, but not only with the presentation of your case, but help the arbitrators in their deliberations. It's important, I think, to also have a clear list of issues on which the experts do not agree for the same reason. You also might have an opportunity to consider when they'll testify. Perhaps you might want experts to testify in the ordinary presentation of your case, perhaps days apart, but you might want to think about working together to perhaps have them testify on the same day, and perhaps you might want to consider having your experts be able to question one another. That can certainly streamline the presentation of evidence. It can make sure everybody's focusing in on the dispute. It can assist the arbitrators with deliberations, and I think everyone can perhaps understand, the problems presented when experts do testify days apart. That's just one other area that you may want to consider some cooperation on. And it would be, of course, unique to your particular case and circumstances. And this really can't be overstated. It's important to not over-litigate, and I think it's good to keep in mind that if you want to arbitrate more as attorneys, you really should not be cavalier about your client's pocketbook or the pocketbook of anyone else for that matter. Now let's talk a little bit more about additional things you can do to avoid what we and others call over-litigating. George?
You should try and, or not try, actually you should prepare a statement of stipulated facts. And most arbitrators will require this of the parties through their attorneys. It avoids unnecessary testimony and hearing time, and it lets the arbitrators focus on what they have to discern and decide, and can aid in the examination of well-founded motions. I can't emphasize enough the importance of a statement, a joint statement of stipulated facts, and it's crucial to the success of the case with the arbitrator understanding the issues, and allows the attorneys to be more concise in getting their case heard and ruled upon.
Now, narrowing facts is important, so too is narrowing issues, correct, George?
That's right. There also should be a statement of issues not in dispute and issues to be decided by the arbitrator. You should always determine if you can stipulate on issues that are not in dispute and narrow the issues that are to be decided by the arbitrator. It will be a more effective arbitration. It will go faster, it will be more efficient, and the arbitrator will know by the issues being narrowed what exactly is expected to be decided by the arbitrator or arbitrators.
Michelle, you wanted to say something else, I think, about narrowing issues, correct?
Yeah, of course it's really important, kind of going back to slide 18 where we talk about a statement of stipulated facts. That's really critical in in a summary judgment motion. Now, I'm not saying that you should necessarily file summary judgment motions in arbitration, but sometimes there are some legitimate reasons to do so. Sometimes you've got a multi-count complaint. Sometimes there really is just a question of law, and that can be cut short and further streamline the arbitration process by going ahead and submitting that question of law and letting the arbitrator just decide that. So if you're going to file summary judgment motions, of course it would be wonderful for the attorneys to get together and actually prepare that statement of stipulated facts.
Now moving on to potential stipulations that would affect the presentation of the case in arbitration. I typically send out a letter when initially being retained to serve as an arbitrator that sets forth perhaps 20, 25 potential areas that the attorneys and their clients may want to consider stipulating to. Even if there's already a stipulation in place, you can have subsequent stipulations, and they're not things that should be done in every case. It's just a list of things to consider, and it is by no means exhaustive. And I have a few examples here. Can the two remaining arbitrators select a third when one withdraws, or can the two who remain decide the case? Regarding this, if your arbitration is being conducted pursuant to the Florida Arbitration Code, Section 682.06 says that the remaining arbitrators can continue. That also references the potential that you have an umpire involved when your arbitrators, if you have two left, can't decide. But I think it's important to contemplate the possibility of one of your arbitrators not being able to actually continue through the end of the final hearing. It would be a shame if that contingency wasn't planned for in advance and it caused everyone to have to spend quite a bit of time waiting for the panel to get reconstituted if you didn't want to have something in place already. Another thing to consider, can witnesses appear telephonically or through video conferencing? I think video conferencing is something that can certainly drive down costs, and when costs involve significant travel expenses, there are costs to video conference facilities, but a lot of desktop opportunities exist on people's computers to facilitate video conferencing, and that is something that can certainly be considered. Sometimes people want that. Sometimes people want people to attend live. Again, thought should be given to it early. Will there be a limit to the number of witnesses? That can certainly, affect preparation and the presentation. And will there be a limit to the number of depositions? And how long will they last? Another thing you might want to consider that's not on this slide is whether experts, as I said before, you might want to consider having them testify concurrently or on the same day. But you want to also consider the point of maybe having that joint meeting early on of them to help refine the work they will do for you, and consider having them generate a joint report. Other things regarding evidence submitted. Can all the testimony be submitted by transcript or video, or will you have to have people attend live? And will there be one notebook or compilation of documentary evidence submitted about which there is no objection? I think whenever you can submit one copy of something, the better, whether it is what is in dispute or not in dispute. Michelle, did you want to say something more about a notebook?
Yes, I did, Richard. I think of that movie, The Notebook, and this is far less romantic, I hate to tell you, but what I as an arbitrator like to see, and I think Richard and George would agree, is we want to have you folks present us with one notebook that contains all of the evidence that you've stipulated, all of the documents that you've stipulated will go into evidence. And then in that same notebook, you can have a category for the evidence that the documentary evidence you intend to present, but that the other side has not stipulated to. So for us, just to have one notebook makes life so much easier, because if you submit 2 or 3 different notebooks, then we're in a position where we're back and forth, trying to review what really is the evidence and what really isn't part of the evidence for our consideration.
And it doesn't obviously have to be a notebook. It just has to be one compilation, so that we're getting one set of documents and evidence. It can be on a disk and it can be otherwise. When you have redundant materials presented, sometimes they may be parties may present the same information in different ways at different times. That will slow down the deliberation. It will diminish the functionality, if you will, of even having the submission in the first place. So this is a very important thing, and it's one of those points that advocates in arbitration should be prepared to work cooperatively on. Paying the arbitrators is an important topic that should be addressed also early on. You might have how the arbitrators are to be paid, set in your initial contract with the initial arbitration clause. You may have reached a subsequent agreement. There may be a court order, but who pays whom is an important part of preparing and actually initially selecting arbitrators and getting the arbitration set. Because what you don't want to have happen is have arbitrators ultimately give you the condition of pay the deposit or we can't continue with the arbitration. It's very hard to have a predictable timeline when the issue of payment of the arbitrators has not been dealt with. You need to look at also any engagement letters that you might get from your arbitrators to be aware that you're not going to get tripped up by any cancellation fees. It would be a very bad thing, even if you're trying to do a good thing in mediating the case, that you mediate the case and resolve it so close to the arbitration date that you ultimately are looked to pay the cancellation fee. So just be aware that it should be addressed in your arbitration clause, ideally, if you're at the stage of actually drafting clauses, so there's no uncertainty and no litigation that has to take place over that. And if it's not set forth clearly in the arbitration clause, make sure that you get an agreement as early as you can about the payment of the arbitrators. Because without that, you can just build in the likelihood of additional litigation on the subject or additional delays if ultimately things have to be rescheduled. Michelle, do you want to talk a little bit about the Florida Arbitration Code in this context?
Yes, Section 682.11 Florida statutes, which is part of the Florida Arbitration Code, has a provision that in the absence of an agreement regarding the arbitrator's fees, those fees shall be paid as provided in the arbitrator's award. So definitely keep that in mind. Typically speaking, your arbitration provision is going to indicate how the arbitrator's fees are to be divided or are to be paid. But just keep in mind that the arbitrator has the discretion pursuant to Florida statute to determine how those fees are going to be paid.
Now, let's turn our attention to the actual scheduling of the final hearing. George, can you take us through some of the things to be considered here?
Yes. I have rarely ever had attorneys estimate the length of days for arbitration that is sufficient to cover the arbitration. I think the attorneys perceive that it'll go more efficiently than it does. It won't be as time consuming, and therefore something can be arbitrated in a day and a half or 2 days when in fact it may take 4 days. And it's been my experience that oftentimes there are not enough days set aside based on the estimated time for the arbitration, the estimated time made by the attorneys. I've never had an arbitration that I can think of that actually too many days were set aside and we actually finished quicker than we thought we would. It's very important to try and set the arbitration up so that it is continuous. That is, it has a beginning and an end in a consecutive manner. Sometimes you may arbitrate on a Thursday and Friday and then go over to Monday and Tuesday. That's not really a problem. But you don't want to arbitrate and then because of scheduling problems, perhaps with the attorneys, the parties, or witnesses, then wait for another 2 or 3 weeks to pick up where you left off. it's extremely important for your case and for the arbitrator to make a good, sound decision that this arbitration be tried on consecutive days. Make sure that when you schedule the arbitration that you've allowed plenty of time to complete discovery and file any meaningful motions, and then you can prepare for the arbitration itself. So if it is scheduled and people have set aside that time, not just the arbitrator, but the witnesses, the clients, and any experts you may have that are going to appear at the arbitration, continuing just creates more downtime. So it's important to make sure that all the witnesses and the clients and the parties, attorneys in the court, the arbitrator or arbitrators are available at that time. Also to keep in mind is, as far as the final hearing is concerned, is that reasoned awards are more expensive than awards that are made at the close of the trial or very briefly shortly thereafter.
On this topic of scheduling the final hearing, I think one of the reasons it's a good idea to try to have at least one party representative attend the preliminary conference for the purpose of generating this schedule is so that they can be in the loop. That is an important aspect, I think, not only of having them understand the goals of the arbitrators being an efficient and lean process, but having them involved in the actual scheduling of when the final hearing will take place. Also, sometimes we will see people grab a few extra days or one extra day than they think it might take. I think, personally, it's better when you're scheduling an arbitration to maybe add on one day more than you think it will take, rather than say, optimistically, it's my hope that we can get it done in 2 days or in 3 days. It's better to be safe, I think, and grab the extra day. And then as soon as the advocates realize that that extra day is not needed, release it so that it can be utilized by the neutrals who are serving as your arbitrators, assuming your arbitrators are neutrals. And sometimes when you have, let's say, 4 days set aside initially and it only takes 3 days to present the case, that fourth day, if the arbitrators choose to have it be that way, can be a day built in for deliberation. So when in doubt, don't try to make it sound like you can be fast. Instead, be cautious and maybe allow for the extra day when you're initially setting the conference, so that you're not scrambling and trying to conduct an arbitration with too little time to do it. Because then what happens is you start and you have then the increased likelihood of a big delay in time for everybody to reconvene again to actually complete the arbitration. Just a few things to think about when scheduling the final hearing. Now let's turn now to what arbitration law might apply to your particular arbitration. Again, we're talking primarily about Florida because that's where we are, and if any of you are from out of state, we would direct you to look at your state. Can we talk about this a little bit now?
Yes, I had something went offline for a minute, but I can hear you again. This is Michelle, and I just want to talk a little bit about arbitration law, whether it's the FAC, which is Florida Arbitration Code, or the FAA. And if you look at what the FAA applies to, you can see that's a pretty broad brush there. Not necessarily with the maritime transactions, but you know from your law school days that interstate commerce can be very broadly construed. And so that might take into account many different arbitrations. And of course you have to remember that due to the supremacy clause, the FAA will supersede the FAC. So that federal law is going to supersede that state law. But, it's really typically made easy for us. We don't generally have to construe both the state law and the federal law as it relates to an arbitration, because most of the time, and this kind of leads us into our next slide, most of the time there's going to be a stipulation between the parties that what might even precede a stipulation is the arbitration provision itself will say that the Florida Arbitration Code applies to this arbitration, or it may say that the FAA, the Federal Arbitration Act applies. So generally speaking, you're not going to have to deal with two sets of laws, state and federal, because most of the time either the arbitration provision will indicate what body of law applies, or the parties themselves can just stipulate.
And George, when it comes to evidence, is there a rule of thumb?
Yes, there is a rule of thumb. It is generally within the arbitrator's discretion to determine what is admissible. The rules of procedure applicable to the process are different because the arbitrator can determine the admissibility or relevance or materiality of the evidence offered, and conformity to legal rules of evidence will not apply. When I discuss this issue of the kind of a relaxed rule of admissibility, as I call it, in an arbitration, when I discuss this with the attorneys prior to arbitration, generally I'm asked to use the rules of civil procedure and evidence, the standard rules, as far as admissibility, the standard rules that would be applied in a courtroom, in a trial. And they are narrower than the arbitration rules as far as allowing evidence in that may be material. The arbitration is the purpose of the arbitration is to hear all of the evidence that may be relevant in the case and then make that decision. It is not as narrow as the rules are for a trial. One of the grounds to vacate an arbitration award is the refusal to hear evidence, and it seems to me that that probably is the most prevalent basis if an arbitration is overturned, is because the arbitrator did not allow certain evidence to be admitted during the course of the arbitration. So the arbitrator is going to be more lenient no matter what rules are followed. In all likelihood, he or she is going to be more lenient, or the panel is going to be more lenient in receiving evidence.
Now, procedural rules may come to you with the initial agreement. You may choose to select your own set of rules that you all adopt and come up with as advocates, or you may look for organizations that have rules in place that will allow you to have guideposts, if you will, in the presentation of the matter. These rules that exist often give arbitrators broad discretion. We've already touched on that. And they speak of encouraging an expedited process. If you go to the CPR rules, for instance, you can see kind of the flavor of what is intended to be achieved by their set of rules. I'd like to read it. It says, the primary objective of arbitration is to arrive at a just and enforceable result based on a private procedure that is fair, expeditious, economical, and less burdensome and adversarial than litigation. The above objective is most likely to be achieved if the parties and their attorneys, and this again is found in the introduction to the CPR rules, adopt well-designed rules of procedure, select skilled arbitrators who are able and willing to actively manage the process, limit the issues to focus on the core of the dispute, and cooperate on procedural matters even while being effective advocates on substantive issues. So you can see that there is a desire to see rules actually achieve these goals that we've been talking about. And it's important just to understand you can adopt rules that you like, and your agreement may already say that you have to follow certain rules. And I've seen people have an agreement that says these are the rules that will apply, and then subsequently stipulate to incorporate a different set of rules. These are just all things that you should be considering proactively, and the earlier the better. Let's turn now to the submissions. We talked a little bit earlier about the submission and what is presented and how it's presented. George, let's talk about the submissions a little bit more.
As I mentioned earlier, in the different categories of cases suitable for arbitration, construction is one of the ones that comes to mind right away, particularly in the area of submission of documents or materials for the arbitration. I have received in some construction cases 3 or 4 large boxes of documents, and I guess they had an order in the mind of the attorney, but it's not readily apparent to the arbitrator as to what order they intend to follow. You spend too much time as an arbitrator searching for the document when boxes are submitted of document after document after document, many of which are duplicative. They're redundant, and they add time to the arbitration. They can be confusing, and it's really, particularly in construction cases, and I'm sure it's true in other types of cases as well, overdone at times with so many documents submitted. So what I seek is a book, a notebook, a large notebook, and give me one book with all the evidence both parties have agreed is admissible, and give me another notebook from each of the parties, or a combined notebook of those documents which would be objected to during the course of the arbitration. It's so important to have some kind of organization in this regard, rather than the arbitrator having 14 notebooks in front of him and no real semblance of organization.
What an arbitrator doesn't want to do necessarily is open up a banker's box and see photocopies bound with rubber bands and no other indicators of organization. Richard, did you want to, Michelle, this is Richard. Do you want to say anything about submissions also?
Yeah, I don't want to beat a dead horse here, but remember, quote, the notebook. And the other thing that I would add is something I actually experienced in an arbitration. The attorneys did a fantastic job in this case I arbitrated, and one of the things that one of the lawyers did was actually prepare a summary of this one document that was printed in very, very small font, and had literally like thousands of entries in it that I had to review, and he actually prepared a summary. Now, the summary he prepared and submitted was not evidence, but it was very, very helpful for me in examining the evidence. Because, when you're sitting down as an arbitrator and you're reviewing computer-generated documents, and they're extensive and tiny and endless, it is really helpful to have, it was very helpful to have that summary to kind of guide me in my review of that evidence.
Now moving on to the decision making, this is now, of course, speaking in terms of when you have a panel. There may be some things that you want to have the chair alone decide. You may find that it adds to efficiencies, and if your statute and your rules are silent, or if you want to modify what they provide, you should really give some thought to what the chair decides. The decision or award at the end of the arbitration sometimes comes out in the form of a simple award. Sometimes it comes out in the form of a more lengthy reasoned decision. George, can you talk a little bit about things to consider here?
Yes. You can ask the arbitrator to prepare or submit a stipulated form of decision, and does you as an attorney representing a client in an arbitration need to understand whether your client wants or needs findings of fact and conclusions of law. Remember that there's a limited basis for review and or appeal and for vacating an arbitration, and that doing a reasoned arbitration just ups the ante as far as the potential for appeal. Another area to consider in an award is, have the parties bestowed upon the arbitrator the ability to award attorney's fees. The benefits of arbitration are its finality, and those opinions that are fully reasoned with findings of fact were uncommon historically, and they have not been favored by arbitrators because they wanted to limit the basis for appeal. When the parties request a reasoned award, it can open the door for additional review. Also, in arbitration, if the arbitrator is prepared to do so in a sole arbitration, single arbitrator, they can make their ruling at the close of the case orally and explain to the parties and the attorneys why they're ruling the way they are. So there are many ways to approach this, but the reasoned award, in our view, is more costly, time-consuming, and certainly it's the expensive way to go. And in fact, if the arbitrator gives a reasoned opinion at the close of the case while the parties and the attorneys are present, that seems in most instances to satisfy the parties as well as the attorneys as to the basis for the award.
And Michelle, take us now to a little bit more of a discussion on attorney's fees.
Yes, we've seen kind of a squirrely interpretation by our state courts when it comes to attorney's fees in arbitration. So I want to try to provide a little bit of clarity here for the lawyers listening in, because this is obviously, an attorney's fee award can be a substantial portion of your award sometimes. So let's take a few minutes and kind of outline for you what you need to understand about attorney's fees in arbitration in Florida under the Florida Arbitration Code. Under the Florida Arbitration Code, we as arbitrators do not have the power to enter an attorney's fee award. And when I say that, what I mean is when we render a final award, it will not contain a specific amount of attorney's fees that we would be awarding to one party or the other. Now, obviously, you could have an arbitrator, you could bestow upon the arbitrator by express agreement between the parties and or their counsel the authority to determine the amount of attorney's fees. But absent that agreement, arbitrators under the Florida Arbitration Code do not have the power to establish an attorney's fee award. So what is it that we as arbitrators have the power to do? Well, if you present a case to us that has an attorney's fee claim and a particular theory of liability, we find on your behalf under a particular theory of liability that would grant you under Florida law the right to recover attorney's fees, then it's very important that we as arbitrators indicate what theory of law that the claimant prevailed on. Because if not, when you take your arbitration award and go to court to have the judge actually determine the amount of fees, the judge won't have jurisdiction to award those fees if the arbitrator has not set forth a theory of liability that would carry an attorney's fee award. So it might be useful for you lawyers to take a look at these cases up on the screen. I have shepherdized them. They are still good law, but they basically stand for the proposition that I have just outlined, that you do have to make sure your award sets forth the theory of liability for purposes of awarding attorney's fees. And prior to our webinar today, I've had the chance to talk to other arbitrators about whether or not they've awarded fees in their cases, attorney's fees, and oftentimes in certain kinds of arbitrations, the parties will stipulate, and so the arbitrator will go ahead and issue an award of attorney's fees.
And this is Richard. I'd like to talk a little bit more about mediating the case while arbitration is pending. Mediation is certainly a possibility in a case that is set to be arbitrated, just like in a case set in the court system, and mediation should be encouraged. If you haven't mediated yet, be sure to keep an eye on the potential cancellation fees of the arbitrators, as I referenced previously, and think about the right time to mediate so as to have enough information, but perhaps not yet all the information you may want to have prior to arbitrating. And if your mediation doesn't result in settlement, consider a high-low for your arbitration. If you're mediating and then think about arbitrating, be aware of the confidentiality ramifications to having the same person potentially mediate and then arbitrate. You need to be very careful making that decision. It might be best to have people with two different people with two different hats on. But if you think that may be a possibility, raise it with the mediator before the mediation so she or he can address the ramifications with the parties that relate to confidentiality. It's important, I think, when you can address those concerns, when you're going to have the same person doing both things, to deal with it before they're engaged on either level or at the first level, that of being the mediator, if that's taking place before you contemplate the arbitration. Let's turn now to the impact of the actual arbitration clause. I said earlier that the dissatisfaction that a lot of people have comes from cost and time, lack of preparation on the part of advocates, lack of management, if you will, on the part of arbitrators. Some of the earliest opportunities to affect the process and affect the design that will hopefully ultimately yield greater satisfaction and a greater likelihood of realizing the intended benefits of arbitration is at the phase of actually drafting the arbitration clause. It's important, I think, if you're responsible for or can in any way influence the drafting of the arbitration clauses that are used by you or your clients. It's important to not miss the opportunity to customize the process from the selection of who will ultimately be your arbitrator to the applicable law of arbitration to the applicable rules that will be utilized, and all the way through to perhaps the nature of the stipulations to be entered and the drafting of the award. It's important, I think, to really realize that you can first start sowing the seeds for effective arbitration and a more satisfactory process for everybody by trying to influence the actual drafting of the arbitration clause that will set in motion ultimately the arbitration that you will be a participant in. So we have just a few moments left. If I am looking at the correct time, we have about 7 minutes left. I wanted to point out to you all the course number. This has been approved by the Florida Bar for continuing education credits. On this slide you will see the Florida Bar course number. And in just a moment I'm going to turn to my colleagues George Sprinkel and Michelle Jernigan to kind of present our closing remarks. But the course number is 1303318N. N as in Nancy. So again, the Florida Bar course number is 1303318N.
Again,
If anybody had any questions about how to access the materials or access the archive of any of our webinars, you'll see at the bottom of this slide the email for Catherine Klasny. And we would invite you to send any questions to her, perhaps about the course number or recording. And you see our individual email addresses here as well. Again, I'm Richard Lord, and my colleagues George Sprinkel and Michelle Jernigan, we are all interested in answering any questions after this presentation that you may have regarding any substantive area of arbitration. Michelle, George, I'll turn it to you. Is there anything else that either one of you would like to say in conclusion? And then if we have time, we can try to address a few of the questions that we've received in advance of today's webinar.
Yeah, just a couple things, Richard and George, and to all our participants, we really appreciate you taking time out of your busy day to join us, and we hope that this webinar will be of some use for you as you move forward with your practices. You know, I hear negative things from lawyers about arbitration. You know, some lawyers really don't like the arbitration process, and I think sometimes arbitration gets more of a negative image than perhaps it deserves, and I think that some of that negative image arises from adhesion contracts in the employment relationship context and in consumer transactions. And just as a quick aside, I know somebody one time who leased an automobile, and you know, almost all those lease agreements contain arbitration provisions, and that person was a lawyer, and he said, you know, I'm not going to sign an arbitration provision, so he exited out, and guess what? They still sold him the car, or they still leased him the car. So, but you know, this negative image has led to the introduction of a bill in Congress called the Arbitration Fairness Act of 2011. And according to my last research on this act it really hasn't gotten anywhere. It's kind of died in committee. But the purpose of the act would be to prevent corporations from requiring consumer disputes and employment cases to be heard in arbitration, and would instead grant employees and consumers the right to have their disputes in court if they so choose. But, you know, I think that arbitration can be a useful process when you do spend a little bit of time on the front end in connection with your opposing counsel and your arbitrator and trying to make the process fit the fuss. And when you sit down and think about what rules should be applicable, how you want to streamline the process, and really the various aspects that we've covered. But I want to kind of bring us back around to what Stepanowicz, author and law professor, said about arbitration. He says, more than ever, arbitration must be understood not as a unitary concept, but as a spectrum of possibilities and a realm of choice that demands more active participation by those who use, regulate, and comment on arbitration processes. So, simply stated, arbitration can be a fantastic tool. Use it to your advantage by tailoring the process in a way that best meets the needs of the particular dispute.
George, is there anything you'd like to add?
Yes, I just wanted to say that, Michelle, I don't think anybody could have summarized it better than you have, and Stepanowicz, who is one of the leading authorities as far as arbitration, in his quote is an excellent way to close the seminar, and I hope the participants have enjoyed it, and I know I have. And maybe we can do something like this again in the future.
Now, we did solicit questions in advance when we sent out the invitations. We've tried to incorporate some of those questions into the presentation, so hopefully you've seen answers to your questions. There are two that stood out as things that we did not incorporate expressly, but might be good for us to comment on. The first relates to likes and dislikes of arbitrators, those things that we observe that we like or dislike. Is there anything else that maybe bears repeating or that we haven't touched on yet, George or Michelle?
Yeah, I have a comment, and it's true not only in court and trials, but especially true in arbitration. Arbitration, to be successful, requires the cooperation of the attorneys. It doesn't lend itself to the kind of what we call Rambo type of advocacy by some attorneys. It requires patience, it requires give and take, and it requires cooperating attorneys who are courteous to each other and to the arbitrator. So I think it's important to remember that being aggressive is not what accomplishes your goal. It's being thorough, being prepared, and and presenting all of the facts to the court and all of the case law, and let the arbitrator or arbitrators decide.
And someone asked a question about means of enforcement and discovery issues in the context of arbitration. Do either one of you have anything you'd like to share about that?
Well, arbitrators have a wide range of latitude in their powers, and so, I believe that they would have the authority to enforce discovery agreements or enforce a failure to comply with discovery.
Well, that brings us to the conclusion of this webinar, and we invite you to visit our website for a schedule of upcoming seminars and webinars. We do have in the works a presentation that will be, at least its working title is E-Discovery and Electronic Forensics. So you might want to keep an eye out in your email inbox for invitations and announcements about that. And on behalf of Upchurch, Watson, White, and Max, and the University of Florida Levin College of Law Institute for Dispute Resolution, this is Richard Lord thanking you on behalf of myself and Michelle Jernigan and George Sprinkel for joining us today. This concludes the webinar.